Welcome back everybody to these lessons on jurisprudence. As a quick introduction, if you want to support this project and get access to additional content and materials, please consider becoming a channel member. This will also ensure that we can keep producing content and doing what we love, which is the creation of legal content for free. And alternatively, if you want to just make a one-off donation, please consider using the super thanks option under the video below. Now, this video specifically is going to be the last video looking at the sociological theories of law. It's going to be the last video looking at this basic introduction to jurisprudence. We might do some more advanced concepts in jurisprudence in the future, because there are lots of other elements of the law that we haven't yet really considered in much detail. This has just been a basic overview of the key major themes. We've been talking about natural law, we've talked about legal positivism, and we've talked about sociological theories of law, the sort of three main pillars of jurisprudential thought. Like I said, we can talk in detail about critical theory and critical legal theory. We could talk about feminist interpretations of law. We could talk about some of the more radical theories of law, anarchist theories of law, for example, and all these different things. We can even go into the ideas that we've looked at at the moment in more detail. And we could also talk about the philosophy of law from the perspective of the specific subdisciplines. So the philosophy of criminal law, the philosophy of tort, for example, the idea and theory of contracts, all of which we will likely do in the future, potentially. But for now, this is just going to round off the series of videos that we've talked about in relation to jurisprudence in its general form. And we're going to finish by talking about the works of sociologist Max Weber, and talk about what Max Weber believed about the law as part of his broader sociological theories. Okay, so this is the final lesson looking at sociological theories, talking about the legal theories developed by Max Weber. We've spoken already about Marx and Marxism and Marxist theories of law, and we also talked about the theories of law as expressed by the sociologist Emile Durkheim, the sort of consensus structuralist theories of Emile Durkheim as well. So we're just going to round this off by talking about Max Weber. As a basic introduction, Max Weber was actually somebody who trained as a lawyer. So one of the things that is important to note here is that his background as a legal professional, as a legal individual who was a trained lawyer, of course, could and does, in fact, play a very key and very central role in his broader theories of sociology and his broader theories of how law plays a role within sociology, his sociological theories of law. What Weber does is highlight the importance of understanding society through the lens of different systems. He takes this sort of systems-based approach, and so what he does in doing this and in taking this systems-based approach is distinguish what he calls a formal system versus the substantive systems, the distinguishing features of those two systems in this regard. And what Weber does and what Weber argues is that the difference in these systems relates to the rules and procedures that are required for internal decision-making. Weber adds to this concept that materials are applied in the system either irrationally or rationally. And what Weber argues is when we start to think about these systems and the rational application of things within these systems, the rational law, the way in which law intersects in this broader conversation, is one of the main preconditions for the existence of capitalism. And so he justifies this on the basis that what the rational law does is provide necessity, certainty, and predictability. These are all very important concepts within the broader conversation about market capitalism. And so he makes this link between law and capitalism, and the rational law and the development and the existence, the preconditions of the existence of capitalism, essentially arguing that this idea of law being something of a provision of certainty and predictability, whether or not somebody is guilty of a crime, can be predictably determined on the basis of evidence that is presented, and so a law, for example, is not unpredictable. Okay, the application of the law is very much a predictable system that is applied. So these are all, like he said, elements, important elements that are related to the idea of and aspects of market capitalism. And so what Weber says is that the formal rationalization of law is the result of capitalism interested in the formal law and the legal procedure. And this really does ground his understanding of the law as being a broader conception of capitalism, the result of capitalism. Capitalism exists and began to develop out of the sort of feudalism and mercantile projects that existed in the sort of 1700s. We then start to see the development of capitalism in and around the development of the Industrial Revolution. And at this same time, according to Max Weber, we see the formal rationalization of law as the result of this development of capitalism. And this really gets to the question of the ways in which and the reasons and justifications for obeying the law. What Weber states is that there exists three kinds of, quote, legal domination, a system by which people are obliged to obey the law. You have this idea of traditional domination, in which legitimacy is justified on the basis that on the sanctity of old rules and powers. You then have what is known as charismatic domination, which is justified on the basis of devotion to the exceptional sanctity, heroism, or explanatory character of an individual person. And then finally, you have this idea of the legal rationale, the justification that rests on, quote, the beliefs in the legality of enacted rules and the right of those elevated to authority under such rules to issue commands. So all of these ideas sort of give us the kinds of legal domination, the ways in which law is able to be obeyed in this regard. Of the three, of course, as you would understand, what Max Weber does is emphasize the importance of the latter, the idea of legal rationalism, the idea of the rationalization of law as a method of obeying the law. When society is dominated by this idea of a charismatic leader, the second of these conceptions, legal thought is formally and substantially irrational. It doesn't operate in a rational setting.